A corporation is recognized by the state as a legal person, possessing rights and responsibilities. Yet it suffers from an absolute physical limitation. It has no physical form. A corporation cannot sign contracts, it cannot shake hands, and it cannot act on its own behalf. Because of this limitation, the corporation must interface with the physical world entirely through human representatives. This diagram shows the ideal legal structure for that interface. The corporation, known as the principal, grants what is called actual authority to an agent, typically a director or an employee. That agent is then authorized to negotiate with a third party, such as a contractor or a vendor. When actual authority is successfully deployed, the agent acts as a perfect conduit. Their actions bridge the gap, creating a binding contract directly between the corporate principal and the third party. Commercial law relies on the legal predictability of this triangular exchange of authority. The system breaks down when an agent acts without the principal's actual authority, yet proceeds to sign a contract with a third party anyway. Looking back at the diagram, if the actual authority line shatters, the law must arbitrate between two innocent victims, the corporation that never authorized the deal and the third party who provided goods or services in good faith. To resolve this commercial deadlock, courts deploy the IRAC methodology. IRAC is a strict analytical framework standing for issue, rule, application, and conclusion. We begin with the first phase, defining the issue. The explicit legal issue is this: under what exact conditions can a principal be legally bound to a contract by an agent who possesses zero actual authority? The common law answers this question through the doctrine of ostensible authority. This is a safety net designed to prioritize a corporation's outward appearances over its internal secrets. We can observe how this safety net operates by examining the 1964 Court of Appeal case, Freeman and Lockyer v. Buckhurst Park Properties. Moving the framework to the next stage, we extract the governing rule from the facts of this specific dispute. The defendant company had a formal board of directors. One specific director, Kapoor, acted as the managing director. He made executive decisions and ran the site with the board's full knowledge. Crucially, however, the board had never formally appointed him to the managing director position. While acting in this capacity, Kapoor hired the plaintiffs, a firm of architects, to develop an estate for the company. The architects completed the work and submitted their invoice. The company refused to pay. Their defense was that Kapoor lacked the actual authority to hire contractors because he was never officially made managing director. The board silently acquiesced to Kapoor acting as the boss when it suited them, but then attempted to use their own administrative failure as a shield to avoid paying a legitimate contractor. Lord Justice Diplock delivered a judgment formulating the modern rule for ostensible authority, grounding it in the principle of estoppel. Estoppel is a legal doctrine preventing a party from asserting a fact that contradicts what they previously established as truth through their own actions. Diplock's premise is straightforward. If a company holds out someone as having authority, they are estoppeled or prevented from later denying that authority to escape a contract. This checklist outlines Diplock's strict four-point test. First, there must be a representation made to the contractor that the agent had authority. Second, this representation must be made by a person or body who actually possesses authority, such as the board of directors. Third, the contractor must have genuinely relied upon this representation to enter the contract. And fourth, the company must have had the legal capacity to make such a contract in the first place. Applying this rule to the facts of Freeman, by allowing Kapoor to act as managing director, the board made a representation. The architects relied on it to do the work. Therefore, the company is bound to the contract and must pay. The Freeman rule establishes a rigid threshold. Ostensible authority is not created by the lies of a rogue agent. It is created by the principal's own representations. We enter the application phase to test how courts apply Diplock's strict rule when the rogue agent isn't a director, but a lower-level administrative officer. We look at the 1971 case of Panorama Developments versus Fidelis Furnishing Fabrics. The facts involve a company secretary named Mr. Bain. Bain fraudulently hired a fleet of luxury cars for his own personal use, telling the car hire company they were required for ferrying Fidelis corporate clients. Bain accumulated a massive bill and then vanished. The car hire company, Panorama, sued the principal corporation, Fidelis, to recover the debt. Fidelis argued that historically, a company secretary was viewed by the law as a mere clerk. Under that historical definition, a clerk has zero actual or implied authority to sign commercial contracts. To hold Fidelis liable for the bill, the court had to determine if merely giving someone the title of company secretary satisfied Lord Diplock's requirement for a binding representation of authority. Lord Denning delivered the leading judgment, focusing heavily on aligning the common law with modern commercial realities. Denning ruled that the role of the company secretary had evolved. It was no longer a clerical position. The secretary was now recognized as the chief administrative officer of the company. Returning to the checklist to apply Diplock's first 2 points, Denning ruled that by officially appointing someone to the role of company secretary, the board of directors makes an ongoing, implied representation to the entire world that this person holds authority for administrative contracts, such as hiring cars. Applying the third point, the court confirmed the car hire company relied directly on this title when handing over the keys. Bain was a fraud, acting without actual authority. Yet the Panorama application proves that a corporate job title itself serves as the binding representation required by the Freeman Rule. We reached the conclusion stage of the framework, synthesizing the outcomes of these precedents. In both Freeman and Panorama, despite the agent going rogue and breaking internal protocol, the principal is firmly bound to the contract, protecting the innocent third party. This doctrine serves as a mechanism for economic risk allocation. When forced to assign fault between an innocent third party and a principal whose agent went rogue, the law forces the principal to bear the commercial loss. The principal is the party who created the risk by placing the agent in a position of apparent power. The courts consistently prioritize the safety and velocity of external commercial transactions over a company's internal bureaucratic failures. Looking at the agency diagram one last time, the distinction is clear. Actual authority is merely a private internal understanding. Ostensible authority is a public-facing architectural feature of the company. Every title, office space, and implied power granted to an employee acts as a live legal representation to the market. Companies must aggressively police the boundaries of their agents' apparent power, or they risk being bound by contracts they never intended to sign. Under the IRAC protocol, ostensible authority ensures that the mere appearance of corporate power becomes a binding, inescapable legal reality.